All right, we might get started. We've got a couple of hundred people already here and many more joining. Thank you to everybody on the call for joining us. During lockdown, during some back into our lockdown phase, for all of those affected, like we are, then I hope that this is a useful session, gives you time to get across all of the issues that are affecting employment in Australia and employment law. I'm joined today by Simon Obee, who is the principal lawyer at EI Legal and head of professional services at Employment Innovations. Simon has over 15 years experience in employment law, and I know firsthand through using him as both a client and working with him on other matters that he is an exceptional lawyer and a really good guy to work with. So thank you, Simon, for joining us and giving us your time yet again with these updates.
Yeah, no worries. Hi, Ben. Hi, everyone.
Thanks, mate. So look, this is the first time in about 6 months that we've had to update. So there's a fair bit to get across. Conscious that there are always changes to employment laws. In fact, even as recently as today, we've seen the New South Wales responding to the local lockdowns with grants for businesses that are affected of up to $10,000. And I'm sure that we'll see other changes coming from other states over the next couple of days as well. Equally, we're now back into lockdown, but all of the laws that we spent many hours discussing during 2020 have expired. So they were the special laws that were enacted to help businesses manage COVID lockdowns and the flexibility around all of that. And so now we're back into lockdown without the benefit of some of those laws. But for today, the things that we will be covering are the changes that have really happened in the first half of this year, and that many of which will come into effect during the second half of the year. So let me just quickly rattle off all of those things that we'll be talking about. The minimum wage update, superannuation rate increase and other super changes, new casual employment laws, proposed changes to the sexual harassment laws and miscarriage leave that has been introduced, changes to the general retail award, and actually maybe I'm doubling up here, and increased flexibility for part-time retail workers. That probably are the changes to the retail award that we're talking about. As we go through these topics, please feel free to add questions to the Q&A section. I'll try to address any questions I can in real time. Otherwise, we'll leave it at the very end. Please just be careful not to put your questions into the chat box. The Q&A box in Zoom is helpful in that we can prioritize different questions and answer them offline and online as well. We'll also be making a copy of this presentation available after we finish, so you'll receive that via email. And we have some other content which I encourage you to delve into. We've today released a remote work report for 2021. It comes off, we did another report in earlier 2020, and it's an update with some really interesting findings around how the world is responding to the remote work world. And also later this week on Thursday, we have the last in our 6-part series, The World Awakens, which is dealing with the transition to the new way of working post-COVID, and dealing with, we've been speaking to great entrepreneurs and business owners around how they've adapted to the new world of work. So with that, I might move into the very first point, minimum wage increases. So I mean, usually the Fair Work Commission makes an order that the minimum wage increases for award-free and award-covered employees commences on the 1st of July each year. But in the over the last couple of years, we see them stagger those increases throughout the year. They've done something similar again this year. Could you just talk our listeners and watchers through what has happened this year with the minimum wage increase?
Yeah, sure. Thanks, Ben. So, yeah, as Ben said, usually the increase comes into effect in 1st of July, but last year, because of COVID, they had a different approach, and they had 3 staggered dates, and they've done something very similar this year. But first things first, what is the rate change? Well, the minimum wage has increased by 2.5%, and that is for award-free employees and award-covered employees. So award-free employees, the rate has gone up to $20.33 per hour, or $772.60 per week. The increase is going to come into effect on one of the 3 dates. So either the first full pay period on or after the 1st of July, 1st of September, or the 1st of November. And similar to last year, the Fair Work Commission has given businesses or industries that it considered most impacted by COVID the greatest amount of time to bring in the increase. So businesses in the aviation and tourism industries in particular have been given the longest amount of time. So I'll go through now the different awards and the different dates that the increase is coming into effect. But I suppose as a really sort of preliminary point, it is really important, obviously, for businesses to understand which modern award applies to their business, or which modern awards, it could be multiple, that apply to their business. You know, many employers are across that and have been across that for a long time. But if you do have any uncertainty about if a modern award applies to your workforce, you know, do get in touch and get some advice about that. The majority of employees in Australia are covered by a modern award. So if you've taken the position that an award doesn't apply to your business, just make sure you've really made some informed decisions about that. So 1st of September 2021, that is the date that the increase is coming into effect for the General Retail Award. That is the only award that has the 1st of September date. That industry sector was judged to have been sort of moderately affected by COVID, and so they were given the 1st of September date. Then there are 22, I think, modern awards that have the 1st of November for the date of the increase to wages, and those are listed on that slide. As I said, they're predominantly businesses in the sort of tourism and aviation sectors. You know, a lot of really common awards in there: hospitality, restaurant, etc. So that is 1st of November for those guys. And then everyone else, if you're covered by an award that wasn't on that previous slide, then the 1st of July is the date for the increase, or to be exact, the first full pay period on or after 1st of July. So the date the increase will come in will depend on how you structure your payment dates. So all other awards and award-free employees are going to be hit by the 1st of July date. That includes awards such as clerks, fast food, manufacturing, and some of the other common ones listed on that slide. Before I move on to some other related matters with the increase, a couple of questions I always get asked is, if we're already paying above the award rate, does that mean we have to increase our rates by 2.5%? And the answer to that is no. Your obligation is just to make sure that you're paying at least the new minimum wage set in the award. So it could well be that if you're just paying slightly above the award minimum at the moment, that the new award rate is going to take over what you're paying. So just bear that in mind. The other question I get asked is how this affects businesses who operate under an enterprise agreement. If you operate under an enterprise agreement, then the base rate of pay, that's the rate of pay without any loadings or penalties added under the enterprise agreement, can't fall below the base rate of pay in the award. So if the award rate has overtaken the enterprise agreement rate, you need to pay the award rate instead. That can be, quite complex to work out, particularly if you've got an old enterprise agreement, working out what is the applicable award base rate to compare it with. But yeah, if you need any help with that, do get in touch. We do a lot of work on that topic this time of year, which keeps us very busy. Just finishing off on the minimum wage, as with previous years, a couple of other things in the Fair Work Act are increasing as of the 1st of July. So the first thing is the high income threshold, which is going from 153,600 to 158,500 per annum. And the high income threshold has three relevances, I suppose. The first thing is if an employee earns over that amount per year, they can't bring a claim for unfair dismissal if their employment is terminated, unless they're covered by a modern award or an enterprise agreement. But it generally means that high earning employees, businesses can follow a more sort of informal process if they're terminating their employment. So that is relevant. Also, the maximum damages in unfair dismissal claims is calculated as half of the high income threshold. So that is going up to 79,250. And then the third thing is the minimum earnings for a guarantee of annual earnings is based on the high income threshold. And what that means is if you have an employee who earns more than the high income threshold, so more than 158,500 after 1st of July, you can give them a written undertaking, which is called a guarantee of annual earnings. And basically that will mean that a modern award that would otherwise apply to them no longer applies. So it's useful to have that sort of clause in your employment contracts if you do have those high earning employees. And then the last thing I'd say on the minimum wage increase is the minimum wage is referred to in the Fair Work Information Statement. That is a statement, a document you have to give to all new employees when they start employment, which details their basic rights. Because that refers to the minimum wage, that will be updated any day soon. So just make sure that you're giving the correct version out to new employees. I'm sure the new version will be uploaded into Employment Hero as soon as it's available. But for anyone else, just keep an eye on the Fair Work Ombudsman website for that. I think that's all I was going to say on minimum wage, Ben.
Great, thanks, mate. Yeah, a couple of points just for clients or customers of Employment Hero. If you're using Employment Hero payroll, then the modern awards, if you're using our modern awards, digital modern award rule sets, they will be updated in line with the timings that Simon has just mentioned. So it's just a matter of applying the update to your payroll system, or to the payroll system, and all of those changes will be automatically updated. Also, yeah, we will have the Fair Work Information Statement updated and put into the system so employees can access it through their document portal, and that will keep you compliant there. All right, Simon, we'll move on to the next big thing. Changes to compulsory. Actually, before we move on, Simon, there's a couple of questions which I think are manageable on this topic, so we might try and knock a few of them off before we move on. I saw one that was from Esther, which was, what about annualized salary agreements where the base rate already has a 25% loading? It's an interesting question because the annual salary has been calculated with reference to the minimum wage. If the minimum wage increases, does the annualized salary also have to increase?
Yeah, so I think that's a question about some modern awards say that if you pay a 25% buffer, then certain provisions in the award don't apply, such as overtime and penalty rates. So I think that is in, it's either in the hospitality or restaurant award. One of those awards has that provision. I've never had to think
put you on the
about
spot.
it, but I suppose the way the award is drafted is it says you have to pay a 25% buffer on top of the minimum wage, and so when the minimum wage increases, I would say the annual salary has to go up with it. I'm sure that's how it would work.
So Esther, we might have
I can't see how else it would work otherwise, you know.
Yeah.
Look at that, and we'll confirm it on our post-webinar communications. But yeah, I'm sure it impacts annual salaries in the same way.
All right. Well, sorry for putting you on the spot there, but good,
No,
well managed. The next question I think I can answer, which is from Amita. With minimum wages, we have fortnightly payroll, which will start next on the 8th of July with new pay rates schedule. Should we be implementing from the 1st of July or the 8th of July? The answer, which unless it's changed in the last year, has always been the same, which is that the increases apply from the start of the first pay period commencing on or after the 1st of July. So if your first full pay period is on the 8th of July, then that's when the increases take effect. Another question here is the high income threshold figure inclusive of super?
No, it's not. So if you're calculating someone's earnings for the purpose of working out if they earn over the high income threshold or not, super isn't taken into account. The only things so that answers that question, but for just to expand on it a little, the only earnings you take into account are fixed earnings, so things like commissions or bonuses or anything which is uncertain aren't included in the earnings. But there is also a prohibition on including super in the earnings calculation, regardless of whether you're paying a salary sort of inclusive or exclusive. You ignore super for the purpose of working that out.
Yep. There's a few here that are maybe a little too specific. So an anonymous attendee asked about the SHADS award. If you have specific questions regarding specific awards and need advice from a good lawyer, then please email or get in touch with Simon. I'm sure we have your contact details at the back of this, and we'll share those before this finishes, and also via an email. So please feel free to use Simon and his team for any specific advice issues. This question here from Kelly: we have some overhead roles, finance, marketing, sales, but at non-managerial levels. We are bound by the HIGA for hospitality industry, but for those support roles, they're more likely award free instead of being listed in the award. Can we offer employment contracts for those roles on a common law basis, or should we stick with the high income guarantee, HIGA, but offer an annualized salary on the basis that we need to add at least 25%? Maybe that is a bit too specific. We might move on rather than get into those ones. And the next question is dealing with super. So let's move on to the changes to the compulsory superannuation rate. Aside from the minimum wage increase, we have to be across the compulsory superannuation increase. It's increasing from 9.5% to 10% from the 1st of July, with staggered increases of up to 12% by 2025, as you can see in Simon's presentation. How can businesses prepare for that, for these changes, and what other changes to super do we know are coming?
Yeah, so as Ben said, we know that super is going to be gradually increased over the next few years. So one of the questions which is coming up a lot on this topic is whether it's possible to arrange matters so that the overall outgoings for an employer aren't increasing, and the employee can absorb the increases into their salary. So it's been a topic of some debate, but as far as I can see, there hasn't been any court decision on this particular point, but it does seem to be generally accepted in lots of commentary that I read, that you can make a salary package inclusive of super, and when the super rate goes up, the overall package stays the same, so there's not an additional cost for the employer, which will in effect mean that the employee's base rate of pay will be decreasing. Now, I think if you are going to do that sort of thing, you want to be very, very clear about it in your employment contract. I would advise against something which just says you're paid 100 grand inclusive of super. I think if you want to rely on that sort of provision, you really want to spell it out. You want to say something like you're paid a total package of 100k that includes your salary and super contributions. If the super rate goes up, your total package will remain the same, which in effect will mean your base salary decreases. If you've got that in your employment contract and an employee has agreed to that, I think you're in reasonably safe position to proceed on that basis. But as I say, I haven't seen any definite judicial sort of consideration of that, but it does seem to be accepted that is possible. So that is something that a lot of people are asking about at the moment, but I hope that provides some clarity on that point. The other are on the 1st of November 2021, there is going to be the introduction of superannuation stapling, is what it's being called, which will be quite a significant change, really, which will mean that employees' super funds follow them where they go, wherever they go, and there will be an obligation on new employers to check what an employee's superannuation fund is and to pay super into that fund. So the ATO will provide a facility for employers to be able to check that. So that is a change to the current position, where if an employee doesn't nominate a superannuation fund, then the super is paid to the employer's default fund. This is changing that and saying if an employee doesn't tell you what their super fund is, employer, you need to go out and find what it is. You're only allowed to use your employer's default fund if the employee hasn't got a super fund already, for example, if they're new to the workforce. So the details of that are still to come, but yeah, the ATO will need to be providing some new facilities, I should think, to enable employers to do that. And the idea behind this is obviously to try and make sure that employees just have the one super fund. They're only paying one set of fees. You know, it is better for them overall. So it does make sense. The second thing that we know that is coming with super is on the 1st of July 2022. There is a plan to remove the minimum monthly earnings threshold for super contribution. So at the moment, employees generally have to earn at least $450 per month before they get superannuation contributions. It's a lesser amount under certain awards. I think in hospitality and restaurant, it's $350 a month, but generally they have to be earning $450 a month before they get super contributions. In the federal budget, it was announced that from 1st of July 2022, that minimum threshold is being removed, which will help support low-income workers. So I think that's all I've got on super, Ben.
Cool. Well, the same question has come up a number of times in here, which is around the date for the super increase. Is it the 1st of July or the first full pay period? I think, correct me if I'm wrong, but I think it's the same answer as before. You run your pay in your first full pay period after the 1st of July, and that's when the increased super amount is applied from. I don't know how else you could do it, but it's the first full pay period after the 1st of July.
Yeah, I think that's right, but yeah, we can double check that and confirm that's the case.
Yeah, and you addressed the question which has come up a few times in here around whether or not the 0.5% increase needs to be added on, or whether it can be absorbed into the salary. Okay, well let's move on to the next topic. Sorry, just on the super issues as well for Employment Hero customers, we will be updating the platform to ensure that the increased superannuation amount, 10%, is applied automatically from that time. And secondly, we are also working towards launching our superannuation supermarket to accommodate stapling from the 1st of November, which is when that legislation comes into effect. We've looked at the obligations for employers under the new regime, and they are onerous, and we want to make sure that it's as streamlined as possible. If you have to go and log into the ATO portal and do a super lookup every time an employee doesn't choose a super fund or tell you their existing super fund, it's going to add a lot of time to your onboarding process, which we will try to find solutions for. Whilst I've been speaking, we've launched our first poll, which you probably can see. If you are an employer, will you require employees to absorb superannuation increases in their salary package? Well, it's a bit of a provocative question, and we will show you the results in just a second. Just while people are still completing the survey, I'll flip to our next discussion point, which is casual conversion. Simon, back in March, there were, and before you answer this, I'll finish the poll, but I'll just set it up. So back in March, there were some changes to the law regarding casual employment. Can you recap those changes and let us know what happened regarding casual conversions on or before the 26th of September 2021, and maybe tell us why that date is relevant. But before you answer that question, I will share the results of the poll. So 73% of people on the call will definitely not be absorbing the super threshold into the base rate. 5% will be. Simon said there's no law saying you can't do it, but there are maybe some considerations around, whether or not it should be passed on. 12% are unsure, and 10% say it's not relevant to me. So Simon, maybe I'll pass to you for the discussion on casual conversions. Simon?
Yeah, big thing to be aware about. Yeah, so did I cut out for a minute there?
You did, you're just frozen, but you're back. It's what happens when we're in lockdown and we've got kids consuming all our bandwidth around the home.
Yeah, yeah, okay, we'll shout out if it goes out again. I can try a different source of internet maybe. But yeah, so
Actually, Simon, I think
changes
it might be
to
worth.
casual laws, but that
You're a bit laggy there, Simon. If you do have another.
yeah, let me yeah.
So while you're doing that, maybe I'll just wait for you to come back on, and I can
Yeah,
start talking through these
give me
points.
1 sec.
Yeah, sure. So as Simon was about to say, there is, for the first time in Australian history, there is a definition of casual employment, which is quite ironic, given that we've probably all been casual employees at some point in the past, and it's just never been defined. It was basically, if you weren't permanent, then you were casual. That was the way it worked. But the federal government passed legislation to clarify and define exactly what casual employment is. And it is no firm advanced commitment to continuing or indefinite work according to an agreed pattern of work. So a casual is somebody who is literally coming in to fill a shift, but they don't plan on coming back because they don't have a pattern of work which they're working towards, and they don't have any expectation of ongoing employment. Simon, you there?
Yeah, I think I'm back. Can you hear me all right?
Certainly can.
Yeah, okay. All right. Well, so yeah, you've covered the new definition of casual employment. That came into effect 27th of March. So you know, at the very least, it probably means you need to update your employment contracts to refer to that. If you're an Employment Hero customer, of course, they've been updated already. The other change which came into effect on the same date at the end of March was a new protection against casual employees being able to double dip on entitlement. So if they're later found to be, in fact, a permanent employee, could they claim backdated annual leave, redundancy, notice payments? Well, there's new legislation which says that any casual loading paid to them can be offset against any entitlements they might want to claim. To get the advantage of that protection, businesses need to have something quite specific in their employment contract. So again, if you haven't updated your casual employment contracts since the end of March, now's the time to do it. The third thing is a new obligation to give casual employees a casual employment information statement. Most people are familiar with the requirement to provide new employees a Fair Work information statement. We've now got something additional for casual employees, so they need to get the Fair Work information statement and the casual employment information statement. That obligation is already law, so if you're engaging any new casual employees, you need to be providing them that on commencement or before commencement. In terms of your existing casual workforce, small businesses were supposed to give that information statement to employees, existing casual employees, as soon as possible after the 27th of March. So if you haven't done it, do it now. Non-small businesses, so those with 15 employees or more, they have got until the 27th of September to do that. So as soon as practicable, on or after 27th of September, you need to provide the new casual employment information statement to existing casual employees. And then the last thing, which is by far the most complicated and which has some important obligations which are going to come into effect by the end of September, is casual conversion. So I'll just spend a little bit of time running people through the obligations. And there are two different obligations, or the law operates in two different ways, depending on whether you are a small business, less than 15 employees, or a non-small business, 15 or more employees. And there's two different sets of obligations. We'll deal with non-small businesses first. So for them, I think the best way to think about the new obligations for casual conversion, and casual conversion, I should probably have said, is an obligation to convert casual employees into permanent employment, so full-time or part-time. There are two different obligations a non-small business first has to think about. The first is your obligations before, on or before 26th of September 2021, and then there are your obligations after that date. And what you have to do on or before the 26th of September is there is an obligation to inform all existing casual employees whether or not they will be offered conversion to permanent employment. So it is a proactive obligation. You need to tell them in writing in a prescribed form whether or not they're going to be offered casual conversion. If you're a non-small business, 15 or more employees, you have to do this. There's no way around it. This is something which is kind of buried in the back of the legislation, and lots of people haven't picked up on it. But if you do need advice on what you have to do, please do get in touch. We've got some great resources on this, which we will share with you after the webinar, I'm sure. So you have to, what you have to do, you have to look at your existing casual workforce, and in respect of each casual employee, you have to work out, have they been employed for 12 months? If so, have in the last 6 months, have they worked a regular pattern of work? And if they have to be offered conversion to permanent employment, unless there are reasonable grounds to not offer conversion. So there is, of course, this reasonableness factor. If you have a reasonable business ground to not offer conversion, then you don't have to do it, but you need to tell the employees the reasons that is not happening. A reasonable business ground might be, for example, you know that in the next few months, the requirement for them to work is going to be reduced, or there's going to be some other change on the horizon, which means they can't keep working that regular pattern of hours that they have been working. But if there are no grounds, which means they can't continue working the regular pattern that they've been doing for the last 6 months, they have to be offered conversion. They might, of course, refuse that offer, but it is an offer that has to be made. So that is the obligation that exists, that has to be done on any date between now and the 26th of September. That is a kind of one-off casual conversion project, I suppose, that needs to be carried out. And then you're in the territory of the New World Order, of the 27th of September onwards, which will be how casual conversion will work from then until, eternity, or until the law is changed. And then what are your obligations? Well, if you're a non-small business, once you have had a casual employee who's been employed for a year, once they've hit that 12 months anniversary, if they have been working in a regular pattern for the last 6 months, then they need to be offered casual conversion, unless there are reasonable grounds not to do so. And there are obligations again to inform the employee in writing of your decision. And then thereafter, the employee will have a right to request conversion every 6 months, which again can be refused on reasonable grounds. So that is businesses with 15 or more employees. I hope that makes sense. For small businesses, less than 15 employees, forget about the September date. The law is already in effect. And what are your obligations? Well, there is no proactive obligation to go out and offer conversion. What you have to do is consider any requests for conversion that you receive. Your casual employees have a right to request conversion to permanent employment once they have at least 12 months service, and if in at least the last 6 months they've worked a regular pattern of hours. Again, that request can be refused on reasonable business grounds, and again, these employees have a right to request conversion every 6 months. So that is it in a nutshell. As I say, we've got some really handy sort of flow charts and guidance which steps you through the different obligations depending on where you are in that particular scenario. We also have some template letters which are also available through Employment Hero, which give you all the different options. You're offering conversion, you're not offering because there's reasonable grounds to do so, etc., etc. The legislation is quite prescriptive about what needs to go into those written communications, but we've got templates for all those purposes, so hopefully it won't be as onerous as it sounds.
Thank you, Simon. It does sound onerous, and it's triggered a whole lot of questions in here. So
Yep.
I might throw a few out if we
Sure.
can, and then we'll move on because there's too many to get to all of them. But the first one is maybe what is a regular pattern of employment?
Yeah, so helpfully the legislation doesn't define what a regular pattern of work is, but there will be cases where it is very clear. If you've got a casual employee who's been doing the same hours each week for the last 6 months, that is going to be a regular pattern. If you've got a casual employee who works some weeks, doesn't work others, some weeks they work 50 hours, some weeks they work 10, that is going to be not a regular pattern of work. The difficulty is going to be those cases in the middle. But what court decisions which have dealt with similar points and not identical points, because this is also new, but similar points about what is meant by regular, seems to encompass both a pattern where an employee is working the same hours on the same days, same start and finish times, same total number of hours. Clearly that's regular, but also it seems to catch if you have an employee who works 20 hours per week every week, but sometimes does Monday and Tuesday and sometimes does Tuesday and Wednesday, that is likely to be regular as well. Certainly frequent absences from work are going to suggest something other than a regular pattern, but just because a casual employee hasn't worked for a week or two in a 6-month period, I don't think that would be enough to take them out of a regular pattern of work if those absences are akin to a permanent employee taking a week's annual leave and then they come back and slot into the pattern they were doing before. But yeah, there's going to be some judgment calls that need to be made. We're obviously doing a lot of work on this at the moment, so if you do need help in deciding what is a regular pattern in your particular workplace, do get in touch.
Great. I think also the expectation is another issue. Even if the person, like you mentioned, they've worked 20 hours a week, but on different days of the week for 12 months, but if you cut them completely, would they be shocked? Did they have an expectation of permanent and ongoing employment? If that's the case, then I think that's the first test, that if their expectation is that they are an employee. Look, there's so many other questions here, but they're quite specific. So we might try and come back to the remainder at the end and see how far we get, because there is still a fair bit to get through. Okay, so let's launch the next poll to our invisible colleague, Jules, behind the scenes. Would you mind launching the next poll if you can? There she goes. Well done. Thank you, Jules. So the next question is, if you are an employer with casual employees, will the new laws mean you will have to convert some of your casual employees to permanent employment? And we'll leave that running while we get the next talking point started, which is proposed changes to sexual harassment laws. Simon, the government has also in the last week, introduced a new bill that makes some changes to the law concerning sexual harassment. Can you tell us more about it?
Sure. Yeah, well, I'll deal with this as quickly as I can. But as Ben said, in the last week, we have seen the Sex Discrimination and Fair Work, Respect at Work Amendment Bill introduced. This is in response to a report on improving sexual harassment in the workplace that the government commissioned. The report, Respect at Work, it was called, made a recommendation of several changes. The government hasn't adopted all of them, which is reasonably controversial to step away from those recommendations. But what they have included in this new bill, which has been introduced in Parliament, is several things. They are extending the time limit that an employee can bring a sexual harassment claim from 6 months to 2 years, and there will be a discretion to grant extensions in exceptional circumstances. That is an acknowledgement of the fact that people often don't feel ready to bring those things to the authorities' attention at the time these things happen. The second thing is clarifying in the Sex Discrimination Act that sex-based harassment is unlawful. So the government felt it was clear enough that sexual harassment is unlawful. That's unwelcome conduct of a sexual nature. Lewd comments. Perhaps, comments about someone's appearance, inappropriate touching, all that kind of stuff is clearly sexual harassment. But they wanted to make clear that sex-based harassment is unlawful too. So that could be conduct based on someone's sex, but of a non-sexual nature. So, for example, ignoring someone because of their sexual gender or ostracizing them, doing things which are harassment, but aren't sexual in nature. That is still against the law. They wanted to make that clear. So there is going to be a new definition of sex-based harassment in legislation, and also the removal of a very strange exemption that existed for state public servants who weren't covered by the Sex Discrimination Act. That is something else which is changing. There are also going to be a couple of changes to the Fair Work Act. The first is to make clear that stop bullying orders, which are an order that an employee can apply for fairly easily at low cost, which gives the Fair Work Commission a power to make an order that they stop being bullied. They can't order compensation, and it can only be used while an employee is still employed. So arguably it has sort of quite little teeth, but they are amending the stop bullying orders language in the Fair Work Act to make sure that it covers sexual harassment. And unlike bullying, which has to be repeated conduct, a one-off event isn't bullying in the legislation. Sexual harassment can be an event that happens once, and an employee can still apply for one of these orders. The next thing they are changing is clarifying that in unfair dismissal laws, that a valid reason for dismissing someone is if they have been guilty of sexual harassment. So adding to sexual harassment in the list of valid reasons for terminating someone's employment, which already includes misconduct, incapacity, etc., making sure that sexual harassment is a valid reason for dismissing someone. So those in a nutshell are the changes. A lot of people have been saying things could have gone further. A lot of what is proposed is just clarifying existing law. Fairly controversial in some sectors, but they haven't gone far enough. Shall I keep going, Ben?
I think we might just quickly mention the results of the previous poll,
yeah, sure.
and then we'll move on. So 50% of people on the call believe that the changes to the casual employment permanent conversion legislation will affect them, and they will need to convert some of their employees to permanent. 30% don't believe it will affect them, and 20% are unsure. I think the fact that 50% will need to make some changes shows just how impactful that legislation is going to be on many employers in the country. So yeah, back to you, mate. You want to keep going on?
Yeah, I think that was all I was going to say on the sexual harassment laws. Yeah. So
okay. Well, Jules, do you want to launch that poll, and we'll just take a quick pulse of whether people think that those changes to the sexual harassment laws have gone far enough, or potentially not far enough. We'll let that run for 30 seconds or so, and then share those results. While that's happening, Simon, we won't comment on the results of that poll, but if you can move on to our next section, which is miscarriage leave. The bill will also enact a new type of leave in the National Employment Standards in the Fair Work Act to provide for paid miscarriage leave for the first time. Can you explain this and how it works?
Yeah, sure. So I guess it was a couple of weeks ago, we had an announcement that the New South Wales government was going to provide, I think, up to 5 days paid leave for state public sector employees who they or their partner suffers a miscarriage. In the bill, the sexual harassment bill, there is also a provision which is going to affect private sector employees if it's enacted, which is to provide for the first time that private sector employees will be able to take up to 2 days paid leave if they or their partner suffers a miscarriage. And how that is going to be affected is to add into the entitlement to compassionate leave the ability to take leave where an employee or their partner suffers a miscarriage. So at the moment we have compassionate leave, which an employee can take up to 2 days leave per occasion where a member of their family or household either dies or suffers a life-threatening illness or injury. They're going to add into the eligible criteria for taking compassionate leave where an employee suffers a miscarriage or their partner does. It'll be 2 days paid leave for part-time and full-time employees, and it'll be unpaid leave for casual. But there's no limit to the number of compassionate days leave you can take. It is just 2 days per occasion, if that makes sense.
Yep, that makes perfect sense. Thank you. So I did, while you were speaking there, and apologies to anyone that was distracted, I shared the results of the prior poll. It looks like the government went sort of hit the nail on the head with the changes. There was 30% think they went far enough, 33% think they didn't go far enough, and 34% aren't sure. So right down the middle. Let's move on to our final discussion topic, Simon, which is very, very new. Yesterday, the government announced some changes to the General Retail Award, handing down a decision concerning the General Retail Industry Award and part-time employees working extra hours. Can you explain that decision from the Fair Work Commission yesterday? Yeah,
sure. So the way the Retail Award is currently drafted for part-time employees, and this is kind of common to a lot of awards, is it has some fairly prescriptive requirements about their arrangement of hours, which has to be agreed when they start employment. So an employee and an employer have to agree under the award when a part-time employee starts work, how many hours they're going to work per week, what days they will perform their hours, and the start and finish times of of when they will be performing that work, and it's currently sort of unclear, I guess, whether when an employee works in addition to those hours by agreement, whether they're paid their ordinary rates of pay or whether they get paid overtime. And what the changes to the retail award will do, and they come into effect on the 1st of July, is they will make clear that a part-time employee can agree to work additional hours and only get paid ordinary time rates and not overtime rates, which is obviously provides a much greater level of flexibility for employers. So, the classic example would be someone is rostered to do a 4-hour shift, but, it's really busy, or someone doesn't turn up and the employer needs to get them to work, an extra hour after their normal finishing time. As long as the employee has agreed to that in writing before the end of that shift, then they just get paid their ordinary hours of work. The award makes clear that agreement in writing can be through a text message. So, it's quite common for employers to text their staff, "Can you work an extra hour this evening?" "Yes, I can." Then you're covered and only need to pay ordinary time rates. So I think it's a welcome addition to the award for employers. As I say, it was unclear previously whether that right existed, and lots of different views about how it operated. But this will provide some certainty going forward. So I think it's a welcome change.
Great. Mate, thank you so much for preparing all of those topics. Very, very useful. And we should be doing this obviously more than once every 6 months because there's so much to cover. We have a ton of questions, and only 2 minutes to address them. So I'll take the opportunity now before we finish to remind people that you can contact Simon, simon.obee@employmentinnovations.com. You can, and we will also email you his contact details. So any specific questions or anything that you need advice on, please reach out to Simon and his team. They're more than happy to help you and work with you. Simon, with the last minute or two, we might just try and knock a few of these questions out. When is the miscarriage law, the changes to the miscarriage leave are going to become enforceable? When can employees start to take advantage of that if necessary?
Yeah, well, I mean, it's before Parliament at the moment, so it really depends whether it gets approved or changed. But I think the government is trying to get this through as quickly as they can. So I would think, unless there's some huge objection to it, which hopefully there won't be, in the next couple of months, I should think it will be made law. But we don't have an exact date yet.
Yeah. A few people asking about, are there templates for casual conversions already in Employment Hero? I don't think that there are. I will follow up. Do you know, Simon, if we've added templates for casual conversion?
Jules will probably know, but if they're not in there already, they're certainly in the wings. They've certainly been something we've put together. So I'd be surprised if they're not there already. But maybe we can confirm that in the follow-up comms.
Cool. Another question that keeps coming up is what happens if a casual employee refuses to sign a conversion or refuses to convert?
Yeah, so it is just an obligation to make an offer. They don't need to accept it. If they don't, then they remain as a casual employee, and you're very safe that they are a genuine casual employee. I mean, I think practically speaking, when conversion is being offered, your obligation as an employer is just to offer conversion on the minimum terms set out by any applicable award. What that will mean in most, if not all circumstances, I would imagine, is that the employee is going to lose that 25% loading that they enjoy as a casual employee. So a lot of employees will will not want to do that. They'll want to remain as a casual employee and reap the benefits of that higher rate of pay. So yeah, I should think that there'll be a lot of employees in that circumstance. If that is the case, they continue as a casual employee. If they change their mind, they have a right to request conversion, after a 6-month waiting period.
Cool. Yeah, that's come up a few times. What happens to their salary? Well, if they do convert to permanent, then they start earning paid leave and their salary should be adjusted. You don't need to continue paying them the casual loading.
Yeah, exactly.
Look, everybody, I'm sorry because we're out of time and there are still 45 questions here. So we'll try and consolidate those questions in our follow-up material and come back to you with answers. Like I keep saying, if there's anything specific that you would like to discuss with a lawyer, Simon is your man. And he is available to speak with you. Thank you so much for being a part of today's event. We enjoy making this material available to you. We're doing everything we can to make employment as easy as possible to manage and as rewarding as possible for everyone. And we will continue to do so. Thank you for your ongoing support and attention, and have a good afternoon. Good luck with COVID if you are in lockdown like we are. Thanks everyone. Have a great afternoon. And Simon, thank you yet again for your participation.
Thanks, Ben. Thanks everyone. Speak to you soon.
Cheers everyone. Thank you.